We're trying today to focus on the human rights dimensions to archives. And we had quite a bit of discussion about that this morning, but this afternoon is squarely in that space. We're going to start with Maeve O'Rourke, who is our own homegrown brilliant human rights expert in these matters, who teaches in Galway University, and she's going to be introduced to you by Professor James Smith, who's visiting us from Boston College, and who is the author of that very significant book called The Architecture of Containment in Ireland, which brought attention for the first time really to what was going on with these huge buildings on the outskirts of every town. So we're going to get going. Just to emphasize, there's no Q&A after each session. We will have a Q&A at the very end at 4:30, and it will be for questions rather than speeches. So we would ask people to ask short questions. We had a very successful one this morning where people stuck to that rule, and that's what we'll try and do today. So James, if you wouldn't mind coming up. Thank you.
Thanks, folks. So I have the great pleasure of introducing my friend and colleague, Dr. Maeve O'Rourke, who is a lecturer in human rights law at the Irish Centre for Human Rights at the University of Galway. Maeve was also a member of the inaugural class of the Young Academy of Ireland, and of note, not directly related to her work that she'll talk about today, but equally important, her monograph entitled Human Rights and the Care of Older People was published just last month by Oxford University Press, and importantly, it is an open access publication. Maeve has been a member of the Justice for Magdalene's research group since 2010, and she is co-director, along with Claire McGettrick, who is also here today, of the Clann project. Maeve was more recently appointed by the Northern Ireland Executive in 2021 as one of a 3-person independent truth recovery design panel. And the output of that work continues to manifest in more recent initiatives in Northern Ireland. Maeve and I have worked along with our JFMR colleagues, Catherine O'Donnell, Claire McGettrick and Mary Steed, and with a large group of survivors and others, many of whom are also here today, to advocate for the Sean McDermott St site of social conscience, or the National Centre for Research and Remembrance, which we'll be talking about all afternoon. On behalf of Maeve and all of us, we wish to thank again Katrina Crowe for organising this important event, and extend our thanks to all of the staff here at the Royal Irish Academy for their hospitality and their welcome today. Please join me in welcoming Dr. Maeve O'Rourke.
I'm extremely grateful to be here, to have been invited to make this presentation. There are many people in this room, and of course many who are not here, whose work has been central to achieving the promise of a National Centre for Research and Remembrance at Sean McDermott St, with its annex of the National Archives of Ireland. And the prospect of that centre working in tandem with a sister institution in Northern Ireland, which we'll learn more about today, just brings a new level of hope, I think, and a glimpse of change which is long overdue and which has been painstakingly sought. It's important to recognise that adopted people and survivors of Ireland's all-island institutional and family separation system have been at the forefront of the campaign to achieve disclosure of personal records and administrative archives, so that individuals can piece together their own history and so that the general public can learn from the horrific abuses of the past and their continuing effects. There's a large community of people affected in the diaspora, and their campaign for information is long-standing, as have been the efforts of relatives of the deceased and intergenerational survivors. In 2019, I was part of a group of academics, practitioners and survivors who mobilised to resist the Retention of Records Bill. This legislation would have sealed completely for at least 75 years every single document in the archives of the Commission to Inquire into Child Abuse, the Residential Institutions Redress Board and the Residential Institutions Redress Review Committee. At an emergency hearing of the Oireachtas Education Committee, which Senator Lynn Ruane convened and which led to that legislation being shelved, Dr. Mary Lodato, a survivor of an industrial school, argued, and I quote, There is a problematic power dynamic at the heart of how histories of abuse are told in Ireland. We have already heard the narrative of the professional classes, lawyers, doctors, and religious orders. Survivors' voices are locked in the board's files. Ensuring access to survivor testimony would help to correct this imbalance of power. She emphasised, of course, how important it is for survivors to give informed consent or not, and I quote, "All living survivors should be contacted in advance of this process. Publicly accessible files could be anonymised or redacted with survivors' consent. Living survivors should be able to participate in the process of researching and writing our history. There should be an opportunity for survivors to supplement the written record with their oral history." In Northern Ireland in 2021, when I was commissioned as part of a 3-person independent truth recovery design panel, I heard from so many people who need the state to gather together and provide access to their personal data. One woman said, and her testimony is emblematic, "I want all paperwork pertaining to me and the birth of my daughter, not the social worker's or director's impression of what I wanted to hear. I want the actual transcripts." Another person, again in a manner common to innumerable people, emphasised the need for administrative archives to be gathered and disclosed. And I quote, "All files must be available for scrutiny. Public records, records held by the mother and baby institutions, any police records, financial records, journals, notes, diaries, medical records, health and social care records, and any other relevant documents held by individuals or organisations. Every document from when the decision was taken to place the mother in the institution through to her departure and to include all relevant information regarding her baby. Parish records, baptismal and death records, maternity money was paid to these institutions. Financial records should be disclosed by the institutions and government departments responsible for these payments." Another example of the submissions made to us when we were in Northern Ireland is the following, and it is excellent that this call was acted upon and the demand remains here in the Republic. "I feel strongly that all records which are not subject to legislative protection, namely those held in the religious orders and other non-governmental institutions, should be seized in a timely manner. This is to avoid the potential destruction and misappropriation of the evidence." So, the people directly affected by Ireland's institutional and family separation abuse are clear that personal access to their own records and public disclosure of the entire administrative archives in a way that protects survivors' privacy, and the opportunity for survivors who wish to give testimony to put it on the public record are essential measures of justice and are crucial to the protection and education of future generations. And human rights law absolutely supports this position. I'll begin with the right to identity and the related rights to data protection in Irish and European law. Access to records means access to identity, and there is hardly a human right more fundamental or more connected to the concept of human dignity than the right to identity. The European Court of Human Rights has established that this right is a core part of the right to respect for private and family life under Article 8 of the European Convention on Human Rights. And according to the European Court, states must provide people with information about their family origins and about their treatment as a person in state care. In 2020, the Irish Court of Appeal recognised as an unenumerated Irish constitutional right the right to have one's identity correctly recognised by the state. And to reach this conclusion, the court drew on the concept of human dignity, which is a founding principle of the Irish Constitution. And the court also referred to European data protection law, which again is based on the notion of human dignity in the sense of being enabled to determine one's own ends and being treated as an individual and as an equal to all others. You might actually be aware that EU GDPR has come to the rescue of Irish survivors and adopted people since it entered into force in 2018. EU law is supreme over any conflicting Irish arrangement, and GDPR has been a crucial tool of adopted people, institutional survivors, and those of us advocating alongside them. It prohibits blanket barriers to accessing one's personal data and was therefore essential to resisting the Retention of Records Bill and also to challenging the Minister for Children's plan in late 2020 to seal entirely the Mother and Baby Homes Commission of Investigation archive that he was due to receive. Under GDPR as well, it's not permissible to restrict data subject rights in ways that are unnecessary or disproportionate. And this principle enabled Claire McGettrick and those of us advocating alongside her, to repeal the 2016 Adoption Information and Tracing Bill, which would have made it a condition of receiving your name at birth that you would undertake never to attempt to contact your parents. We know from the Department of Children's annual implementation plan for survivors and former residents of mother and baby and county home institutions, which Minister O'Gorman emailed yesterday, that the Department of Children is now responding to subject access requests for material in the Mother and Baby Homes Commission of Investigation archive that it holds. It says it's doing so following engagement with the Office of the Attorney General, the Data Protection Commission, and independent experts in the area of GDPR, and it has a dedicated phone line providing information for callers on the subject access request process. And it has completed 1,066 subject access requests, having received 1,090 to date. But GDPR rights and obligations, of course, apply to all other holders of adopted people's and survivors' personal records and testimony. And there is a huge and urgent need for the Irish state to coordinate through independent guidance, monitoring and practical assistance the way that all religious and non-religious bodies, including state and quasi-state entities and the holders of previous inquiry archives are and are not safeguarding personal data and making people aware of and implementing GDPR rights. The 2022 Birth Information and Tracing Act is an important part of the jigsaw, but TUSLA and the AAI and the Department of Children and the Department of Education with its Access to Institutional and Related Records project are not the only data controllers out there. And it's worth noting at this point that mothers are not included in the 2022 Birth Information and Tracing Act, and there are myriad contexts in which institutional and family separation records are held. I think and I hope that the government recognises that the new National Centre for Research and Remembrance will need to gather all relevant archives from all possible sources, whether original or in copy, in order to vindicate the identity and data protection rights and thus the dignity and privacy rights of people affected by the institutional and family separation system. I will go on to discuss other information access rights beyond GDPR, including access to information, to administrative information as part of the right to truth, shortly. But in order to vindicate all of these rights, the state needs to act immediately as a first step to require preservation and to criminalise destruction of any and all relevant records and archives, other than, of course, the information that survivors themselves hold about their life. Dr. Mark Cohen of UCD School of Law and Professor Catherine O'Donnell of UCD School of Philosophy and I have already made representations to government about the need for emergency legislation, and Mark has drafted a suggested bill which draws on the emergency legislation in Northern Ireland, the full title of which is the Preservation of Documents, Historical Institutions, Act, Northern Ireland 2022, which was passed unanimously by the Stormont Assembly as the very final item of business in March 2022 before the Assembly mandate ended. Mark was prompted to do this after finding decades' worth of financial records and business correspondence in the disused Magdalen laundry in Donnybrook in 2018, records, of course, which were not given to the McAleese Committee and which we write about in our edited collection, A Dublin Magdalen Laundry, Donnybrook and Church State Power in Ireland. In our briefing to the Taoiseach on the need for emergency preservation legislation, Mark explained that the Donnybrook records were, and I quote, in an abandoned building prone to vandalism and water ingress and home to a large contingent of pigeons. More comprehensive legislation will be needed in due course, of course, to set out how the National Centre will both receive and manage its archive and, as Maeve emphasised, be sustainably resourced to do so. To comply with GDPR, the Centre will need to ensure data security and will need to protect living individuals' rights to know and be notified about what personal data is held on them, to have access to their personal data, to rectify inaccuracies and supplement gaps, and to object and request erasure depending on the circumstances, bearing in mind that the GDPR does allow for archiving in the public interest and for restriction of certain rights, such as the right to object or to erasure where absolutely necessary in pursuit of that public interest. The legislation should state explicitly that the public interest that archive is pursuing is the protection of human rights and the remedying of human rights violations. There are comparative examples that can be followed, and a number of us here have worked with staff of the Stasi Records Agency to understand how that institution proceeds in accordance with GDPR and in pursuit of human rights. And there are lessons to be learned, both good and some bad, from the Department of Children's handling of the Mother and Baby Homes Commission archive, and from the rollout of the 2022 Birth Information and Tracing Act, and of course from the ongoing Northern Irish investigation. The absolutely core data protection principle that must be respected is that information relating to people who were institutionalised or adopted or abused in related systems is their personal data. Where other people are mentioned in records, such as people in charge, and this information relates to the survivor or adopted person, then this is also the survivor or adopted person's personal data. The Court of Justice of the European Union has been clear that information can relate to more than one person at the same time, and this does not affect its quality as each person's personal data to which the ordinary rights apply. It is also too frequently forgotten or ignored by those who still redact and refuse survivors and adopted people's records that the deceased do not have rights under GDPR which can counteract those of the living. But moving on from personal data and identity rights, it is crucial to address the rights of relatives of the disappeared. And of course, there may be some overlap because information about your disappeared relative may in some cases be information also about you. With many other lawyers and adopted people and survivors, I have argued that Ireland's institutional and family separation system perpetrated the grave human rights violation of enforced disappearance. That is defined in international law as detention or abduction of a person with the state's involvement or acquiescence, following which their fate and whereabouts are concealed. The violation continues for as long as family members are not given every possible piece of information about what happened to their relative. So relatives' rights to know the fate and burial place of their babies, their mothers, their siblings, their aunts, their uncles, and people's right to know the circumstances in which they were separated from family and their family members were separated from them. These are rights that the National Centre for Research and Remembrance will need to fulfil. And of course, they're rights that the state should already be fulfilling in order to bring enforced disappearances to an end. And that brings me now to the comprehensive right to truth, justice, reparation, memorialisation, and guarantees of non-recurrence. These together make up the right to an effective remedy that victims and survivors of gross and systematic human rights violations have under international law. They are the pillars of transitional justice, and none of them is possible without access to information. Truth, justice, reparation, memorialisation, and guarantees of non-recurrence. These require full disclosure, not just of people's personal data to them, and not only of their disappeared relatives' fate, but crucially also disclosure of the administrative archives and other sources of information that reveal the system through which they were abused. When we talk about Ireland's institutional and family separation system, we are talking about systematic arbitrary detention, servitude, forced labour, torture, cruel, inhuman and degrading treatment and punishment, and other gross interferences with private and family life. It is not possible to provide any measure of accountability or to ensure acknowledgement, recognition, public education or institutional reform without releasing the information held to a great extent by those in power that shows and explains how and why these atrocities were permitted to take place and were in practice carried out systematically. As one person put it to us on the Northern Ireland Truth Recovery Design panel, I think that it is very important that the wider records about the institutions, how they were run and who benefited are put into the public domain. Again, the question is, who turned a blind eye, who benefited, and who exploited and why? As Professor Maria Luddy recalled this morning, archival access and access to the truth about systems of oppression is about power. Survivors and adopted people's own right to participate in the disclosure of the truth is paramount in European and international human rights law. In general, the European Court of Human Rights has found under Article 10 of the ECHR that it is an integral part of freedom of expression to seek historical truth. And the state's refusal to allow individual access to original documentary sources for legitimate historical research can violate the right to freedom of expression, according to the court, because freedom of expression includes both freedom to seek and freedom to impart information. Freedom of expression will be an extremely important right when it comes to drafting the new legislation for the National Centre, and again, it's a right that the state should currently be vindicating. Not only does the right require access to administrative archives as well as one's personal data, rather than simply to a narrative created only by, as Dr. Mary Lodato puts it, the professional classes or the official history. But I've argued previously with others that it requires the repeal of previous gagging clauses in the Residential Institutions Redress Board Act and in the Commissions of Investigation Act 2004, which purport to prohibit survivors from speaking publicly of what they told these bodies. It also requires, I believe, positive measures to assist people in putting their own accounts and their responses to the archive on the public record if that is what they wish. The European Court has found in previous case law that Article 10 of the ECHR imposes a positive obligation on states to create a favourable environment for participation in public debate by all concerned. But specifically in the context of investigations into serious human rights abuse, the European Court of Human Rights has been very clear about victims' entitlement to access the evidence under consideration. And I want to dwell on this because I think it is important to consider that the inquiry archives amassed to date, that is, the Ryan Commission Archive, the Magdalene Archive, and the Mother and Baby Homes Commission of Investigation Archive, should not have been gathered in secret. In secret as far as the survivors and adopted people were concerned, except for those whose lawyers received disclosure about their own individual case under the Ryan Commission and the Redress Board. And by extension, gathered in secret as far as the general public was and remains concerned. I only have time to go into the Mother and Baby Homes Commission of Investigations operations, but I have written elsewhere about the Irish legal frameworks underpinning the Magdalene and Ryan Commission inquiries too. And in addition to European human rights law requiring maximum possible disclosure to survivors, which of course did not happen, I actually have found that the inquiry's own Irish legal underpinnings both required more access than the inquiries gave and certainly did not require the level of secrecy imposed. Therefore, the inquiry archives should not be allowed to stay the way they are, which is, on the whole, inaccessible. Inaccessible and then accompanied in the broader context by the ongoing refusal of religious orders in many dioceses to allow access to what they hold, state bodies' refusals to release their records under FOI. When I originally requested access to the Magdalene archive held by the Department of the Taoiseach, I was told the records were held for safekeeping and not for the purposes of the Freedom of Information Act. Then a survivor, with the help of pro bono lawyers, including Colin Smith, who is here, obtained a decision of the Information Commissioner that they were indeed held for the Freedom of Information Act purpose. But now the position is that, although I'm allowed to have the index, searching the archive for what I've asked for would exceed the costs allowable under the Freedom of Information Act. And Sheila Ahern, who is here, has painstakingly tried and failed to use that index to piece together the Magdalene archive from scratch. And part of the problem, as well as we've heard today, is that departmental records have not made it into the National Archives where they should be, and previously public records are increasingly made private in ways that Maria illustrated. So via new legislation for the National Centre for Research and Remembrance, the inquiry archives should be deposited and managed as openly as possible while protecting survivors' privacy rights and respecting other individuals' rights. Those inquiry archives should sit equally alongside all other relevant religious, state and non-state records and archives that the National Centre acquires, ideally with the benefit of a preliminary emergency piece of legislation that requires preservation and prohibits destruction of all relevant records and archives. But I want to get back to the European Court of Human Rights. It has repeatedly stated that where an investigation into alleged serious human rights abuse is taking place, there must be a sufficient element of scrutiny, public scrutiny, of the investigation or its results to secure accountability in practice as well as in theory, and that in all cases, the victim or their next of kin must be involved in the procedure to the extent necessary to safeguard his or her legitimate interests. In 2002, the European Court found a clear violation of these requirements in the case of Paul and Audrey Edwards and the UK. The Edwards' son Christopher had been killed in prison, and an independent inquiry was established which lasted 10 months and heard from 150 witnesses. It proceeded entirely in private and treated Mr. and Mrs. Edwards as witnesses only. They were allowed to attend 3 days of the 10-month inquiry and only when they were giving evidence, and they were not allowed to see the testimony of the other 150 witnesses or the records they produced. They were not legally represented, and they were not entitled to suggest any questions to be asked or avenues of inquiry to be pursued. They had to wait until the final report was published to have any access to the substance of the evidence considered by the inquiry. Now this, I'm sure, sounds extremely familiar. In October 2020, the Mother and Baby Homes Commission of Investigation delivered its final report to the Minister for Children, having gathered an archive of testimony and records that it did not share at all with institutional survivors or adopted people or the public at large during the 6 years of its investigation. When the Commission was getting going in 2015, Claire McGettrick and I set up the Clann project, a collaboration between Adoption Rights Alliance, Justice for Magdalen's Research and the London office of international law firm Hogan Lovells. With 60 solicitors, Hogan Lovells assisted more than 80 people to give witness statements to the Commission. And they also entered into correspondence with the Commission about its procedures on behalf of the Clann project. Over several years, Hogan Lovells, on behalf of the Clann project, requested that survivors and adopted people be enabled to hear and see the evidence of the religious, state and other representatives whose testimony and records might affect them. We reminded the Commission of its obligation under Section 12 of the Commissions of Investigation Act 2004 to disclose to a person who gives evidence to a commission, which of course included survivors, the substance of any evidence in its possession that, in its opinion, the person should be aware of for the purposes of the evidence that person may give or has given to the Commission. Section 11 of the 2004 Act gave the Commission discretion to hold public hearings, for example, of institutional and state representatives, where the Commission was, and I quote, satisfied that it is desirable in the interests of both the investigation and fair procedures to hear all or part of the evidence of a witness in public. The Commission refused to hold any public hearings, and it refused to publish or give to survivors or adopted people any of the evidence it was gathering. The Commission actually refused people access to their own records, even after 2018, when GDPR came in and when the 2004 Act was amended to remove the blanket disapplication of the right of access to personal data. The Commission also refused mothers information it held about their deceased babies. Several survivors, including Philomena Lee, with the assistance of Hogan Lovells, requested permission to give their evidence in public. The Commission refused, even though Section 11(1) of the 2004 Act expressly allows evidence to be heard in public at the request of a witness, or, as I already mentioned, if the Commission believes doing so is in the interests of both the investigation and fair procedures. The Commission did inform Hogan Lovells that people could come and view a transcript of their investigation committee testimony in the Commission's premises, but individuals were not permitted to have a copy. This made it impossible, really, for people to check the accuracy of the Commission's record or respond. And it turned out, when the Commission's report was published, that the Commission had destroyed the audio recordings of 550 people's confidential committee interviews without seeking permission, without giving prior warning, and without making full transcripts. And it was only following a really significant and stressful public pressure campaign that the Minister for Children ensured that backup copies were obtained, and they are now available to people who make subject access requests to him. 5 months after the Commission's report was published, former Commissioner Professor Mary Daly explained at an Oxford University seminar online that the Commission had, however, fully implemented the religious and other alleged wrongdoers' rights to see and comment on the evidence under consideration. Professor Daly explained, and I quote, "If we wrote something that was adverse, critical about an individual or an entity, an institution, we had to write a draft report where we made these critical observations and supply them with the accompanying documentation, and they had a chance to read that, and they had a chance to come back. They came back with a vengeance." By this point, in mid-2021, 8 women, mainly Clann witnesses, who had given their written testimony to the Commission and kept their own copy, had brought High Court judicial review proceedings, again with the assistance of Colin Smith, against the Minister standing in for the now dissolved Commission. And the government agreed to High Court declarations that the Commission had breached the survivors' equal statutory rights as individuals who were identifiable, even if not named in the report, to receive and comment on the draft findings related to them. And the government agreed to append to the Commission's report a notice of all findings, which the survivors would have challenged as inaccurate reflections of their testimony had they been given a chance. These findings include the Commission's conclusions that the nature of the violence suffered by boarded-out children, and I quote, cannot be established, that women, and I quote, were not incarcerated in mother and baby institutions, that there is, and I quote, no evidence, close quote, of women being denied full, free and informed consent to their child's separation from them, and that there is, and I quote, very little evidence of physical abuse. So now the Minister for Children holds the Mother and Baby Homes Commission archive. He has said that he must seal it for 30 years, according to the 2004 Act, which does recognise that archive status as departmental records under the National Archives Act in 1986 and provides for its further sealing after the expiry of the 30-year rule in accordance with Section 8 of the National Archives Act. But at the same time, the Minister is, well, and it's welcome, allowing data subject to access requests in relation to the archive due to GDPR. And he also introduced 2 further changes to the archival arrangement through legislation in October 2020. First, his legislation allowed the Commission to give an entire database of women and children and underlying records to TUSLA, while he kept a copy. And second, his legislation required the Commission to ask survivors whether they would like their confidential committee testimony redacted, so that it didn't identify them before it went to the Minister, and 80 people out of 550 people availed of this option. So this experience goes to show that it is possible to amend the arrangements under which existing inquiry archives are managed. More needs to be done. Lots could be done now while we wait for the National Centre to take shape. I will leave you with the observations of Tom Cronin, an industrial school survivor, when he gave evidence against the Retention of Records Bill in 2019. These precious records should be treated as a treasure and a gift, he said. We must learn from the past mistakes we made in our society and help to lay safeguards that we will need to protect the children of the state into the future. Thank you.